Court is calling 2025 CR 004086. All right, we're back on the record. Could I have parties announced for the state? Defense.
Anita Perez for the defense.
You're charged with assault, family, household, impeding breath or circulation, and in cause number 2025 CR 004086. You're charged with violation of bond or protective order 2 times or more within 12 months.
Thirdery, the courtroom doors swing open, and the tension's thick enough to cut with a knife. A man stands accused of assault, choking, violating bond, and playing the "oh, I didn't know what no contact meant" card. And what's his defense? "Please don't throw me in jail. Let me try to escape the consequences." Yeah, right. Welcome to a legal showdown where the stakes are life-changing, the stakes are high, and the drama, well, it's about to get real.
To those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. Plead guilty, not guilty, or no contest?
No contest.
All right. So in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates.
But those dates are referring to, which I guess we could figure out putting these informations where those were days that the defendant called the victim from jail. So those will be reported to jail.
All right. So
And we've been provided with those, Judge.
I'm sorry?
We've been provided those.
Well, are you stipulating that, because he pled no contest, is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024?
So as far as that, Judge, we're pleading no contest. My client has no.
Here we go, folks. The defendant's lawyer decides it's a great idea to waive a pre-sentence investigation PSI report, because who needs the full picture when you're talking about a history of assault and domestic violence? Just trust that this guy's changed, and that he's matured. Funny, he's been calling the victim from jail, which doesn't exactly scream "I'm trying to better myself." But sure, let's just skip the background check and hope for the best. If that's not setting up a train wreck, I don't know what is mic drop moment. Just how much responsibility is he actually ready to face? Or is it all just another?
He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were 15.
Does he want to testify?
No, Judge. Let me just finish. I'm so sorry.
All right. So you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay. I'll just proceed. Right. I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously.
We're dragging out the story. He's just a guy who's been in jail for 3 months, the defense says, as though being locked up automatically makes you a sympathetic character. Sure, the defendant's been losing weight a whole 110 Ls apparently. But how does that justify choking the mother of your 3 kids? But here's the kicker. He's now trying to move on, and apparently wants to patch up his life with some probation and a dash of "I'm sorry." The defense is throwing in everything but the kitchen sink. Health problems, past abuse, child custody. To make us forget the core of this, he put his hands around her neck. Yeah, let's all pretend that doesn't.
But notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. With respect.
For the Army is part of the equation, seriously, we're supposed to take this man's desire to enlist as a sign of his good intentions. Let's get this straight. He's not only a domestic abuser, but now he's trying to make himself out as a patriot, while also avoiding the real consequences. Oh, and don't forget he's vehemently opposed to a no-contact order with his kids. Sure, buddy, let's pretend this is all about family values when your past includes choking your partner. The court's eating up this turning a new leaf narrative, but we can't ignore the mountain of red flags in his past. Interview 5.
The protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim...
Due to what?
The witness leaving the state.
Okay.
So as we stand here today, we have... obviously, my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, we know that is for a fact. But obviously, he's very concerned for his children. He wants to know their whereabouts, and he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is. Let me see, his name is Eggerson is his last name, Sergeant Eggerson, and I did call the number. Unfortunately, Mr. Ross was in the process of being recruited to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication?
Okay.
Legally.
Well, I would ask the court to take that into consideration, that he has no legal convictions. Under any other ordinary circumstances, he has no prior offenses.
Okay, but
convictions. And so,
but if you're saying
he's a first-time offender,
all right. But if you're saying he's legally entitled to deferred adjudication on this case,
I have no statute.
Oh, right.
If the court, I have no statute. But I'm just saying, as a matter of principle, as a matter of mercy on my client.
Now for the grand finale, the defense is playing the hey, no prior convictions. So let's cut him some slack carb, like it's a golden ticket. Guess what? You can't ignore his history of choking and violating protective orders. This man's not a good candidate for probation. Yet they're still trying to spin him as a misunderstood guy just looking to move on and be a father. The judge isn't buying it, and good for them, because the defendant clearly doesn't get the gravity of his actions. But sure, let's continue pretending like this is all part of some redemption arc reality. Check. No matter how much you sugarcoat it, he's a threat to those around him. His plea for mercy, it just isn't sticking at
contact with being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
All right. So what I can
and
tell
they'll
you,
have to accept the
he's
transfer.
not a good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Well,
in each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors.
Here the defendant's plea for understanding sounds like a bad movie script. He chokes his partner, violates protective orders, and still thinks he deserves some mercy because he hasn't been convicted before. That's not how justice works. Accountability isn't up for debate. No one's buying the story of a man who wants to be a hero, but has a history of violence. This isn't a just one bad mistake situation, it's a pattern of behavior. The judge saw right through the defense's desperate play for leniency. And that's a reminder justice isn't blind, it's just...
There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in Each Cause Number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
they're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion.
4 years in prison, no contact with the victim, and a harsh reminder that not every sob story gets a happy ending. The defendant tried every trick in the book. But justice doesn't care about your excuses or the weight you've lost in jail. It cares about the damage you've done. So what's the real lesson here? Is redemption only for those who actually face their sins? Or do we let people off the hook just because they know how to sound sorry? Crop